And in this first session of this weekend, I have prepared a short note on the classes, last classes, what we Sandeep sir teached us, that is the definitions of international law. And as you can see on the title screen itself, we can see the last class topic, that is definitions of international law. And without wasting time, we are going to a class review of last class. And when we come into the topic, that is the definitions of international law, we can see a timeline in this international law definitions. And again, in this timeline, we can classify these definitions into two, that is old definition and new definition. And this classification has an importance because in this classification, by understanding this classification, we can understand what is the current situation of this international law, what was the situation in the primitive stage of these definitions, and what caused this change from old definition to the new definition of international law. So this classification is helpful for all that. So there are two series of definition, that is old definitions of international law and new definitions of international law. And going to the first definition of international law, and it was given by Jeremy Bentham. We all know that he is a famous jurist, and there is one more importance, that is he coined the term international law. And again, in his book An Introduction to Principles of Morals and Legislation, that is in 1718, and according to his definition, international law is the law governing the relations between states. So according to him, international law is a law, and again, this law governs the relations between states. It is a definition of Jeremy Bentham. And going to the next definition, and all these next definitions are coming under the series of old definitions. And next definition is given by Lord Coleridge. He's a judicial officer, and he's a judicial officer in King's Bench, England. And he defined international law in a case, Kuhn versus Kane. And according to him, international law is collection of usages which civilized states have agreed to observe in their dealings. And I have given a red color to two terms, that is usages and civilized states. And usages, we all know that it is customary rules. And civilized states, this term has an importance because civilized states at that time, in this definition came in the period of 1870s. At that time, there were two classifications for states, that is civilized states and non-civilized states. And civilized states were only included Christian states. Christian states were only considered as civilized states, and non-Christian states were considered as non-civilized states, and they were not part of this international law. So Lord Coleridge said that this international law is some customary rules that is applicable to civilized states while they are in intercourse with one another country. And next definition, that is given by a famous jurist, that is John Austin. We all know him, and it is not a definition. Actually, it's a comment on international law. And his comment on international law is that law is the command of the sovereign, backed by sanctions or punishment. But international law doesn't have its own sovereign sanctions or punishment, anything like that. So international law is a part of positive morality. So by this definition, what Austin says that there is no law like international law. International law is a pseudo law, because there is no sanctions or punishment for enforcing this international law. So countries obeying this international law only by reason of a positive morality. This is what Austin says about international law. And the next definition, it is the definition given by William Edward Hall. And according to him, international law is some rules of conduct that modern civilized states, again there is a usage of the term civilized states, and the civilized states consider as binding in their relations with another, in same nature and degree as a person obey the laws of his country. and it is also enforceable by some means in case of infringement. And in this definition, we can see that the William Edward Hall equals the international law with the domestic law. So the countries obeying the international law like in a way, the person obeys the laws of his country. So this is what William Edward Hall says about international law. And in the second part of this definition, he says that there are some means of there are some means for enforcing this international law. But we have to understand this, that at that time, that is in 1884, at that time, war was the only means in case of any infringement. This is what William Edward Hall says about international law. Then next definition is given by King's Bench of England, that is given in a famous case, that is Western Central Gold Mining Company Limited versus the King. It is given in 1905, and in that King's Bench says that international law may be defined as the rules accepted by civilized states in determining their conduct towards each other and towards each other's subjects. So there is an importance to this definition. It is because till this definition, the states were the only parties to the international law. But by this definition, individuals were also brought within the ambit of international law, and they are introduced one more branches to the international law, the topic of international law, that is the private international law. That is the importance of this King's Bench of England's definition, that is in the famous case. And next definition is by Justice Gray, and he was a US judge, and in a famous case, that is a Paqueta-Habana case, and it is a case related to the confiscation of a Cuban ship by United States. And Justice Gray states that international law is also known as law of nations, is the name of body of rules which, according to the usual definition, regulate the conduct of the civilized states in their intercourse with each other. Next definition is of main importance because it is given by LFL Oppenheim. He was a famous German jurist, and he says about international law that the law of nations is the name for the body of customary and conventional rule which are considered legally binding by civilized states in their intercourse with each other. So till this definition, there were only one source of international law, that is customary rules of international law. But by this definition, LFL Oppenheim recognizes one more source of international law, that is conventional rules. And again, he says that states obey these rules, that is international law, in a good faith. That is the importance of this definition. That is LFL Oppenheim's definition. And then next definition is given by Hackworth in his book, A Digest of International Law in 1906. And he says that international law consists of a body of rules governing the relations between states. And it is a system of jurisprudence which the most parties evolved out of experiences and necessities of situations. So we all know that in domestic law, a customary practice only becomes a law when it is immemorial. But it is not in the case of international law. In international law, the customary practices become law arising out of needs and necessities. It need not be immemorial. That is the importance of the Hackworth's definition. And next definition is by J.J. Brearley, and he says that the law of nations or international law may be defined as the body of rules and principles of action which are binding upon civilized states in their relations with one another. And what is the importance of this definition is that they are recognized two sources till this time, that is the customary rules and conventional rules. And by this definition, J.J. Brearley recognized one more source of international law, that is principles of international law. And coming to the last definition of all series of definitions of international law, that is by Hans Kelsen. And Hans Kelsen's definition is that International law or the law of nations is the body of rules which, according to the usual definition, regulate the conduct of the states in their intercourse with each other. It is the last definition in the whole series of international law. And after this, there has been change from the old definition to the new definition. So we are discussing in these slides what change, what caused these changes from old definition to new definition. I have noted down the first point as that is the conducting of international conventions, and the conventions that is conducted in the last period of 19th century, and that is especially saying the Hague Convention, first and second Hague Conventions that is conducted in 1899 and 1901 is of main importance. And even before the conducting of these conventions, there were agreements. There were bilateral agreements and unilateral agreements were there, but they were lacking the enforcing point. So this lacking of enforcing point caused so many wars. So there needs a really into these definitions of this definitions into definitions of this international law. And second point I have noted down is that the disappearance of distinction between civilized states and non-civilized states. And third point I have noted down is that by 1914 the World War first started, and after that in 1970 the International Red Cross and NGO received Nobel Prize for Peace. And in 1919, League of Nations and International Labour Organization, which are international organization, received was established. So these all incidents needed a really the deep definitions of international law, because these non-state entities and international organizations was part of this international law, became the part of international law. So there needs a change in definitions of international law. So there happened a change in definitions of international law. There came a new series of definitions of international law. And the first definition in that series was the Charles G. Fenwick definition. And he says that international law may be defined as the body of general principles and specific rules which are binding upon the international community. And I have noted down the term international community. The term international community includes international organization, states, non-state entities, even individuals also. So this is the definition that is given by Charles D. Fenwick, and this is given after the World War First, and after that World War Second started in 1939, and in 1944 again International Red Cross received Nobel Prize, and in 1945 they established United Nations Organization instead of League of Nations, and they introduced International Court of Justice. And again going to the new series of definitions of international law, and next is Oppenheim. We have seen the Oppenheim's old series of old definitions of international law. And hello, yes. Yes, okay. In this new series of Oppenheim's international law, am I audible? Is it audible?
Yes, Abhijit, you are audible.
Yes. In this new series, international law, he says that international law is body of rules which are legally binding on states in their intercourse with each other. And this international law is not only applicable to states, but it is applicable to individuals, international organization, and all like that. And this is the new definition of Oppenheim's. And next definition is by William W. Bishop, and he says that international law is a standard of conduct at a given time for states and other entities subject thereto. So international law is not only applicable to states, it is also applicable to non-state entities as well as to individuals. And next definition is that Philip C. Jessup's definition, and in his work A Modern Law of Nations in 1948. And according to him, international law is a law applicable to states in their mutual relations with each other, and also applicable to certain interrelationship of individuals. That is, the private international law, that is we have already mentioned. And the last definition in this new series of international laws is that the Stark's definition of international law. And according to him, international law is some principles and rules of conduct which the states feel themselves to be observed, but it is not mandatorily to be observed, but the states commonly observe this. And this contains some rules and regulations relating to international institutions or organizations and their relations with the state and individual. And there are only 2 slides are remaining. That says about the United Nations Charters, some provisions about United Nations Charter, and the distinction between the old definition and new definitions of international law. And in the United Nations Charter, Article 104 says that United Nations Organization, that the UNA will have a legal personality in the territory of its member states. And Article 105, Clause 1 and Clause 2 gives privileges to the United Nations, gives privileges and immunities to the United Nations Organization and to the representatives of the United Nations Organization in the territory of its member states, respectively. And whether a question was decided by ICJ, that is in the last point I have noted down is that reparation of injuries suffered in the service of United Nations. And this is a case that is relating to short death of a Swedish diplomat in the Israel territory. And he was a Swedish diplomat and he was a representative of the United Nations Organization. But Israel was failed to give the privileges and immunities to this Swedish diplomat. So ICJ held that United Nations Organization, which is an international organization, is also coming under the purview of international law. So Israel is liable to give unliquidated damages to United Nations Organization. And in the last slide, I have included a table showing what is the difference between this old definition and new definitions of international law. And one of the main difference is that in the old definition, international law only included customary rules and convention, but in the new definition, there is customary rules, principles, and conventions are there. And in the old definition, there were the states were the only subjects in international law. But in the new definition, there is states, international organization, non-state entities are there, even individuals are also there. And in the new old definition, international law considers only the civilized states. In new definition, there is no such distinction. And this is what I understood in the last class. Thank you, friends.